In this video, we will conclude our look at issues concerning the performance of a contract for the sale of goods by considering what I call the excuse doctrines. Contract law doctrines that excuse either one or both parties from performing their obligations under the contract because some event occurs after the contract was formed that makes performance substantially more burdensome, impossible, or pointless. The excuse doctrines represent a distinct set of contract law defenses that a party may raise to the enforceability of a contract, defenses that discharge one or both parties from their contractual obligations. Most contract law defenses are based on something that happened before or at the time the contract was formed, that tainted one or both parties' assent to the contract. And that taint is what justifies the party asserting the defense to avoid the contract entirely. The excuse doctrines are different. For each of the excuse doctrines, something happened after the contract was formed, what is commonly referred to as a supervening event, an event that was outside of the parties' contemplation when they agreed to the terms of their contract, and that changes the essential nature of the contractual obligations, such that we think the parties never intended to be bound to these contract terms under the changed circumstances, because the supervening event makes the contract substantially less valuable to one party. The changed circumstances either make it impossible or impracticable for one party to perform what it was obligated to do under the contract, or totally destroys the value of counterperformance for the other party, makes the thing she was supposed to receive under the contract worthless or pointless. Although courts do not always speak in these terms, the excuse doctrines are fundamentally about risk allocation. Which party should bear the risk or cost of a supervening event that occurred? Sometimes a contract will allocate the risk of a supervening event between the parties expressly, using what is called a force majeure clause. Force majeure clauses have recently become a topic of intense interest in the business world as a result of the global COVID pandemic, a supervening event that most parties did not contemplate at the start of 2020. Press pause now and read this example force majeure clause carefully before you continue in this video. So what does this force majeure clause mean exactly? It says that either party's obligation to perform will be excused if certain contingencies occur. Stated differently, the failure to perform will not result in a breach if one of the listed events occurs. Essentially, the clause allocates the risk of one of these events occurring to the party to whom performance would otherwise be due. If a force majeure event occurs, then the party who would otherwise be entitled to performance is left with nothing, neither performance nor a claim for breach. If the party's contract includes a force majeure clause, then the parties have effectively allocated the risk of a supervening event, and specifically who bears the risk of that event occurring. But if the party's contract does not expressly allocate the risk of a supervening event, is it because the parties did not intend the supervening event should excuse performance? Or is it because the parties never contemplated what should happen, because the parties never contemplated the supervening event would occur? If the parties do not manifest an intent in their contract, that is, if the parties' contract does not expressly allocate the risk of a supervening event, and the parties cannot settle any resulting dispute among themselves, then a court will be forced to allocate the risk for the parties. And the court will be essentially faced with two choices. Hold either that the party affected by the supervening event is excused from performance, thus denying the other party the benefit of the performance that she was promised under the contract, or the court can hold that the party affected by the supervening event is not excused from performance, thus forcing that party to perform its contractual obligations under radically changed circumstances, circumstances that make her performance substantially more burdensome, or as an alternative to actual performance to pay the other party damages for breach. The common law of contracts recognizes three related excuse doctrines, three doctrines that you likely remember from your study of the common law. The doctrine of impossibility is the oldest of the three excuse doctrines, where the supervening event that arises makes it literally or actually impossible for one party to perform their contractual obligations. The doctrine of impracticability, which is essentially a more relaxed, less demanding form of impossibility, where the supervening event that arises makes it extremely or unreasonably difficult, expensive, or burdensome to perform, even though performance is still technically possible. And the doctrine of frustration of purpose, where the supervening event does not make performance any more difficult or burdensome, but makes the performance pointless, because the supervening event has fundamentally undermined the party's principal purpose for entering into the contract in the first place. For purposes of this course, our focus is not on these common law doctrines generally. Instead, our focus is on the facets of these doctrines that have been codified in the UCC. Article 2 codifies two of these three doctrines, the doctrine of impossibility under Section 613 and the doctrine of impracticability under Section 615. Let's start with impossibility first. 613 codifies a facet of the common law doctrine of impossibility. Specifically, it excuses a seller from its obligation to perform where the seller's performance, that is, tendering delivery of the goods, becomes impossible due to the destruction of the goods. As with the common law doctrine of impossibility, Section 613 is available to the seller under only very narrow circumstances. Several things must be true for a seller to establish that she is excused from performance under 613. First, the contract must require certain goods for its performance. Some specific goods were necessary for performance. Stated differently, 613 is generally inapplicable where the contract involves fungible goods, for example, commodities like grain, sugar, oil, or batteries. Second, the goods must be identified when the contract was made. Remember, identification is a concept that is addressed in Section 501. What that section requires is that when the contract was made, the goods must be already existing and identified by the parties as the goods that are the subject of their contract. The idea is that the continued existence of those identified goods, the goods that the parties identified as the subject of their contract, was presupposed by the parties, suggesting that the parties did not intend to be bound if those goods were not available. So if the contract is for future goods, that is, goods not in existence at the time the contract was made, 613 is generally inapplicable. Third, the goods must suffer a casualty. They must be destroyed without the fault of either party. That casualty is the supervening event. The event that occurs after the contract was formed, the goods must be destroyed after the contract is made, and that destruction must not be the fault of either party. Thus, the seller is not excused if the seller somehow caused negligently or intentionally the destruction of the goods. For example, if the seller's negligent maintenance of its own warehouse facility results in a fire destroying the goods, then the seller is not excused from performance under 613. Even though the seller's performance may now be literally impossible, the seller will be liable to the buyer for breach. Finally, the goods must be destroyed before the risk of loss for the goods has been transferred to the buyer. So this requires us to recall the rules about when risk of loss passes from a seller to a buyer. Because if the risk of loss has already passed to the buyer has assumed responsibility for any damage or loss. The seller is not responsible. Stated differently, the buyer must still pay the seller for the destroyed goods once the risk of loss has passed. Subsection A to 613 provides that if the goods are completely destroyed, then the contract is avoided. Both parties are excused from performance. Seller need not deliver and the buyer need not pay. But if the goods are only partially destroyed, then under subsection B, the buyer may inspect the goods and has the option to either avoid the contract or decide to accept any remaining goods with an allowance on the purchase price for any damage or deficiency caused to the goods. So 613 codifies the common law doctrine of impossibility, and like the common law doctrine, the availability of 613 as an excuse to performance is quite narrow. By contrast, Section 615, which codifies the common law doctrine of impracticability, is much broader than impossibility, broader and also more amorphous. Again, note, like 613, 615 is only available to sellers, and it excuses a seller for failure to perform its obligations under the contract. In the language of the statute, a delay or delivery of the goods by the seller is not a breach. It is not a breach only if two things are true. First, some supervening event must have occurred. Something unexpected happened. In the language of a statute, a contingency, the non-occurrence of which was a basic assumption of the parties when the contract was made. So the parties' basic assumption was that the supervening event that occurred would not occur. Stated differently, the occurrence of the event was not something that the parties contemplated at the time of contracting. The second requirement is that the supervening event causes delivery, or at least timely delivery of the goods by the seller, impracticable. Impracticable means that it has become commercially unreasonable to expect the seller to still perform because of some increased financial hardship that continued performance would impose on the seller, because it would impose onto the seller an unbargained for loss, a loss so substantial that the contract parties did not necessarily intend at the time of contracting that the seller would have to bear that loss. If these two requirements are satisfied, then the seller's failure to deliver or to deliver on time is not a breach. So the basic rule under 615 is simple. The complexity lies in the details. Specifically, what type of supervening events trigger 615? What kinds of events the non-occurrence of which was a basic assumption of the parties? Stated differently, when, if ever, should a seller be excused from performing the obligation she promised to perform? Comment 4 to 615 provides some guidance. It says that increased cost alone does not excuse the seller's obligation to perform. Costs may always go up and down, and parties must always contemplate that reality. So that kind of post-contracting change should never excuse a party from its obligation to perform. Instead, comment 4 suggests that the cause for increased cost is what matters. What was the event that caused the seller's cost to increase? It must have been something that was beyond what the parties reasonably expected at the time of contracting. So frequently, the impracticability analysis turns on a question of foreseeability, whether the supervening event was in any way foreseeable at the time of contracting. You see this focus on foreseeability reflected in the specialty tires decision that is excerpted in your reading. In that case, the court ruled that the principal inquiry in an impracticability analysis is whether there was a contingency, the non-occurrence of which was a basic assumption underlying the contract. If the event was truly unanticipated, outside of the parties' contemplation at the time of contracting, then the parties did not intend to allocate the risk of that event in their contract. They weren't even thinking about it when their contract was made. But if at the time of contracting, the event was foreseeable or even foreseen, but the seller, that is, the party seeking excuse from performance under the contract, did not protect herself from the risk of its occurrence in the terms of the contract, then the seller has implicitly consented to accepting the risk that that event would occur. Comment 8 seems to support this line of reasoning. Comment 8 reads in part, the exemptions of this section do not apply when the contingency in question is sufficiently foreshadowed at the time of contracting to be included among the business risks which are fairly to be regarded as part of the Dickert terms, either consciously or as a matter of reasonable commercial interpretation from the circumstances. So foreseeability is typically the most important factor in determining whether excuse due to impracticability is available. But foreseeability is not the only factor that matters. Indeed, the specialty tires decision reflects this. In that case, the court said the foreseeability is an incomplete and sometimes misleading test. Anyone can foresee, in some general sense, a whole variety of potential calamities, but that does not mean that he or she will deem them worth bargaining over. Stated differently, some events may be foreseeable at the time of contracting, but they are so unlikely that the parties did not think it was important or necessary to explicitly address what should happen if such events occur. For example, an asteroid can hit the Earth tomorrow and wipe out half of all life on the planet. That's certainly foreseeable. In fact, it's happened at least once before. But it's also so unlikely or remote of a possibility that we would not reasonably expect contract parties to address in the terms of their contract what should happen to their performance obligations if that hopefully very remote contingency came to pass. The specialty tires decision excerpted in the reading makes this point nicely. The principal inquiry in an impracticability analysis is whether there was a contingency, the non-occurrence of which was a basic assumption underlying the contract. It is often said that this question turns on whether the contingency was foreseeable, on the rationale that if it was, the promisor could have sought to negotiate explicit contractual protection. This, however, is an incomplete and sometimes misleading test. Anyone can foresee, in some general sense, a whole variety of potential calamities, but that does not mean that he or she will deem them worth bargaining over. Properly seen, then, foreseeability, while perhaps the most important factor, is at best one factor to be considered in resolving first how likely the occurrence of the event in question was, and second, whether the occurrence, based on past experience, was of such reasonable likelihood that the obligor would not merely foresee the risk, but because of the degree of its likelihood, the obligor should have guarded against it or provided for non-liability against the risk. So to summarize, whether excuse due to impracticability is available to a seller depends on a combination of the foreseeability at the time of contracting of the supervening event that has rendered the seller's obligation substantially more burdensome, and even if the event was foreseeable, the likelihood at the time of contracting that the event would come to pass. One final note, by its terms, impracticability as codified under Article 2 applies to sellers only. A buyer cannot invoke 615 under Article 2. After all, a buyer's only obligation is to pay money, and when the price is set by the contract, that obligation is fixed. It cannot become any more or less burdensome by changed circumstances. But the value or utility of the goods to the buyer may be substantially impaired by supervening events. Imagine, for example, a domestic U.S. buyer contracts to purchase a large quantity of certain hardware from a foreign manufacturer to use in its IT networks. But before the goods are delivered and the buyer pays for the goods, the U.S. government abruptly bans the use of the foreign hardware on all domestic networks. The buyer still has the money to pay, but the goods themselves are now worthless to the buyer. Official Comment 9 to 615 says that the rationale underlying 615 may be applied to buyers as well. This is likely a reference to the common law doctrine of frustration of purpose. That in this example, the buyer may be excused from performance, that is, paying the seller, where the central purpose of the contract has been undermined by a supervening event that the parties did not reasonably expect would occur at the time of contracting. Remember, as we have said at the outset of this course, where the UCC does not displace the common law of contracts supplements the UCC. And with this last point, that concludes our look at when a seller's performance under a contract for the sale of goods may be excused due to either impossibility or commercial impracticability. And that also concludes this week's module. Recall, in this week's module, we examined various issues concerning the performance of a contract for the sale of goods. Who has the obligation to perform? Who has the right to expect performance? And under what circumstances is a party excused from performing such that non-performance is not a breach? In next week's module, we will transition into the final stage of the course, moving beyond performance to breach and remedies for breach.